I have eyelashes for you, Micah, but they're in a mason jar. Do you want them? Alright, guys. We got some crazy court cases today. Thank you, everybody who came out last night. I really appreciate it. But back to our normally scheduled programming.
Hi, what's your name?
Tommy Elwell.
Did you watch the video today?
Yes, yes, sir.
Any questions about your rights?
No.
I do find that the defendant appears before the court in custody. Sir, we have 5 cases for you today. In 25 CR 1999, there is probable cause for 3 counts of identity theft. Those are class 4 felonies. In 25 M 537, there is probable cause for harassment, a class 1 misdemeanor, and theft, a class 2 misdemeanor. In 25 CR 1646, there is probable cause for 1 count of identity theft, a class 4 felony. In 25 CR 1442, there is probable cause for motor vehicle theft in the 2nd degree, a class 4 felony. And in 25 CR 1363, there is probable cause in this case for attempt to commit 1st degree murder, a class 2 felony. Looks like 2 counts of that, and illegal discharge of a firearm, a class 5 felony. Sir,
Oh, he's trying to do all the crimes. All of them.
do you understand the possible penalties for those charges?
Yes, ma'am.
All right. Let's see. In 25 M 537, I do find this to be an act of domestic violence. Do we have Joanne Jensen on the line? Does the district attorney's office have any information from the victim?
We do not, Your Honor.
All right. Sir, the protection order for 25 M 537 will state that you are to have no contact of any kind with Joanne Jensen. You are ordered to vacate the home that she lives in. You are ordered not to share the same residence with her. Sir, do you understand and acknowledge the terms and conditions of the protection order?
Yes, yes, Your Honor.
I will make a finding of force in that case. That means that within 24 hours of your release from custody, you are required to relinquish all firearms within your possession or control, and you must complete a firearms affidavit. Does the defense wish to argue bond today?
Yes, Judge. We would be requesting PR bonds in all 5 cases. If not, we would be asking for lower than standard cash surety or property bonds. It's my understanding that Mr. Elwell does not have any Colorado criminal history other than the 5 cases that are before him. Obviously, they're all allegations at this point, and he is innocent until proven guilty. I would note that pretrial services put him in a risk category of 2, which is the 2nd to lowest risk category, making him an 80% public safety rate and an 85% court appearance rate. Unfortunately, Mr. Elwell cannot afford to post any monetary bond, so even a nominal bond in all of these cases would equate to no bond hold, keeping him in custody. I think this is, he's basically, he was just released or recently released from custody in Texas and made his way out here, as he's been living in Colorado Springs off and on for a couple of years. And so currently he doesn't have any employment. He has no way of posting any monetary amount of bond whatsoever. As I just noted, he has lived in Colorado off and on for a couple of years, so he does have community ties. He also has 5 children whom he is working towards being able to support. Obviously, given the fact that he's not currently employed, he wants to be able to get back into the workforce and then start to help those children. Some of them are minors. They range in ages 5 to 21. He does have transportation to court. He can use public transportation or get rides from other people in the community. And he also has access to his cell phone, so he can receive text alerts as well as stay in communication with his attorney. So for all those reasons, we'd be asking for PR bonds or any alternative lower than standard cash surety or property bonds.
Thank you. What is the DA's position, please?
Your Honor, I'd ask for a standard cash surety property in each case, noting the number of cases, serious allegations in many of these cases. I'd also note that these are 2025 cases, and that it appears that this defendant has had new law violations in Texas since that time, with 2025 felony with conviction and confinement in Texas. I'd also note that the defendant has previous California case history with a 2021 felony, which pretrial services noted there was a failure to appear in that case. I would also note that on the booking report, the defendant did not provide any cell phone number. He was listed as transient, and his next of kin are both out of state area codes for his aunt and his grandmother. So I also have concerns about this defendant's connection to the community besides this long criminal episode in 2025, Your Honor.
Thank you. Sir, the court has considered your individual circumstances. I've considered your other cases. I've considered the statements of your attorney and the position of the district attorney. I do have concerns for the safety of the community, especially noting the allegations in 25 CR 1363. I also have concerns for your ability and willingness to appear for court. It does not appear to the court that your connections to the state of Colorado currently are very substantial, noting a recent case history out of the state of California and a recent case history out of the state of Texas. The court is not going to modify the bonds. Bonds in 25 CR 1999 and 25 CR 1646 and 25 CR 1442, those will all remain at $3,000 cash, surety, or property. In 25 M537, bond will be set at an additional $3,000 cash, surety, or property. And in 25 CR 1363, bond will be set or will remain at $2,000 cash, surety, or property. Sir, it will be a condition of your bond in 25 CR 1363 that you not possess any weapons. And you'll need to attend court for these cases on May 28th, 8:30, Division 19. Thank you.
Thank you.
William Ford.
I'll take a seat. If you give me a moment, I gotta lie there. Take a seat.
Hi, what's your name?
Moving forward.
Did you watch the video today?
Yes, ma'am.
Any questions about your rights?
No, ma'am.
I do find that Mr. Ford appears before the court in custody. There is probable cause in case number 26 CR 2281. The charges are vehicular eluding, a class 5 felony, obstructing a peace officer, a class 2 misdemeanor, careless driving, a class 2 traffic misdemeanor, and number plates not attached to your vehicle, a class B traffic infraction. Do you understand the possible penalties for those charges?
Yes, ma'am.
Your bond is currently set at $2,000 cash, surety, or property. Looks like you also have a $4,000 bond in a different case holding you. Counsel, are you reserving bond argument or proceeding with argument today?
Your Honor, excuse me, I'm sorry, I would request to still argue bond here today. Yes, Your Honor, I would be requesting a PR bond or at least a lower than the $2,000 bond on this case today. Mr. Ford has indicated to me that he has no ability to post a monetary amount of bonds. He may be able to help him out with that $4,000 bond, but certainly not both. He's not currently working, but he is actively looking for work and trying to get interviews lined up. He has lived in Colorado Springs for about 2 years and stays at Springs Rescue Mission. He does have children who he helps support when he is able to, but he also has friends in the area. He does have transportation to and from court. He can walk, take the bus, or get a ride, and he does have access to a phone when he's out of custody. He also does help take care of his 1-year-old granddaughter when he is able to, and it sounds like that is quite often that he does need to help take care of his granddaughter. And so I would be requesting either a PR bond or at least a lower than standard cash surety property bond in this case today for Mr. Ford. Thank you.
Thank you. Thank you. What is the DA's position, please?
Your Honor, we're asking for a cash surety property in this case, noting the allegations of looting and then the foot chase that the defendant took responding officers on. I'd also note, as the court is aware of, that the defendant was held on 26 CR 1458, which is a class 4 felony. The defendant failed to appear to the first appearance in Division 12 yesterday, I believe, or the day before. Also, the defendant is on bond in Douglas County 26M1130, in which he just paid a $1,500 cash surety property bond on May 18th, I believe. I'd also note that the defendant has Texas case history from 2022 and 2026, Your Honor.
Thank you. Mr. Ford, the court has considered your individual circumstances. I've considered your other criminal cases. I've considered the statements of your attorney and the position of the district attorney. I do have concerns about your ability and willingness to appear for court. Based on the allegations in the affidavit here, eluding a police officer and then running from that police officer, it appears to me that that offense probably took place in the afternoon yesterday, and you were supposed to have attended court in the morning in 26 CR 1458. So that's the reason we have a bond in that felony case. The court does also note the case history, recent case history out of the state of Texas. The court is going to maintain the $2,000 cash surety or property bond. And the next court date we have for you on this case is May 28th at 9 o'clock in Division 23. Thank you.
Thank you, Your Honor. And then, Your Honor, just as a heads up, I know that Mr. Buchanan was showing as a Spanish speaker. I don't believe he actually needs an interpreter. We were able to speak with him. So just as a heads up, if you wanted to call that prior to the interpreter getting here, it doesn't appear he does need one.
All right, we'll give it a try. Emmanuel Bugarin, Bugarin. Sir, what is your name?
Manuel Bugarin.
Sir, did you watch the video that was played in the room, or did you read a copy of your constitutional rights?
Yes.
Which? Did you read it or did you watch it?
Watch.
All right, do you have any questions about your constitutional rights? I do find that the defendant appears before the court in custody. Sir, you are here for case number 26 CR 2282. The court did not find probable cause for intimidating a victim or witness, but I did find probable cause for first-degree criminal trespass, a Class 6 felony, false reporting of identifying information to law enforcement, a Class 2 misdemeanor, third-degree criminal trespass, a petty offense, and does the defense waive reading and advisement of the final charge?
Yes, Your Honor.
All right. Sir, do you understand the possible penalties for a Class 6 felony, a Class 2 misdemeanor, and a petty offense?
No.
It's going to be a year to 18 months on the Class 6 felony, up to 120 days, up to $750 on the Class 2 misdemeanor, and then up to 10 days with a $300 fine on the petty offense. Make sense?
Actually, I'll advise you, sir, that you could be facing up to 3 years on the Class 6 felony because it looks like you are currently on parole. So that would be an aggravator. So your bond is currently set at $10,000, but like I said, you do have that parole hold. Counsel, are you reserving bond argument?
Yes, Your Honor. Due to the parole, we'll be reserving.
All right. So, sir, we'll leave your bond at $10,000 cash, surety, or property, but bond can be addressed and potentially modified at the next court date, which will be June 1st at 8:30 in Division 7. That's here in the El Paso County Courthouse. Okay?
Your Honor.
Thank you. Donald Gardner. Hi, what's your name?
Donald Gardner.
Did you watch the video today, sir?
Yeah, I watched him. Couldn't hear him, but
Do you have any questions about your constitutional rights?
yeah.
I'm sorry?
No.
Okay. All right. I do find that Mr. Gardner appears before the court in custody. There is probable cause in case number 26 CR 2288. The charges are vehicular eluding, a Class 5 felony, eluding or attempting to elude a police officer, a Class 2 traffic misdemeanor, reckless driving, a Class 2 traffic misdemeanor, failure to obey police officer, a Class 2 misdemeanor, and registration requirement, a Class B traffic infraction. Sir, do you understand the possible penalties for those charges?
ma'am.
For a Class 5 felony, you're facing a possible prison sentence from 1 to 3 years, sometimes up to 6 years, and a fine from $1,000 to $100,000. For a Class 2 traffic misdemeanor, you are facing 10 days to 90 days in jail and a fine from $150 to $300. For a Class 2 misdemeanor, you're facing up to 120 days in jail and a fine of up to $750. For a Class B traffic infraction, you're facing a fine from $15 to $100. Your bond in this case is currently set at $2,000, cash, surety, or property. Looks like there are 2 other cases holding you as well. I will not be addressing those cases, but in this one, counsel, did you wish to argue bond today or reserve argument for the next court date?
Judge, if I may just have one moment, I didn't get to speak with Mr. Gardner personally. You have 2 bonds, you have $4,000. My advice would be to reserve this day, so the board is going to have them together. Unless he's going to give you this.
She let me get this.
Get this one.
And you tell me.
I can't argue these.
I know that.
So you'll be arguing, if I could take out 40 dollars. Okay, so you understand you can order.
Yeah.
Okay, we wish to proceed with argument today, Judge.
All right.
I would be asking for a PR bond in this case, or in the alternative, a lower than standard cash surety or property bond. I understand that Mr. Gardner is facing charges in this case. However, he is innocent until proven guilty, as well as the other 2 cases that he is currently working towards resolving. I will note, in terms of his criminal history in the last 5 years, they appear to be mostly traffic cases. Actually, all that I'm seeing back to 2018 seem to be all traffic cases other than 1 misdemeanor case. So they're not aggravated cases in any regard in terms of his criminal history. Pretrial services puts him in a risk category of 2, which is the second to lowest risk category, putting him at an 80% public safety rate and an 85% court appearance rate. Mr. Gardner cannot afford to post any extreme amount of monetary bond whatsoever. This is substantiated by the fact that he is on food stamps and Medicaid. He also has significant expenses per month. It seems to be over $1,000. And so he obviously has necessities in terms of life circumstances, and he doesn't think he'll be able to afford to post anything in this case. He is currently working. He does church maintenance. And obviously, while he remains in custody, he has risk of losing his job, as well as losing out on employment to help support his life. He's lived in Colorado Springs for 30 years, and so he does have significant community ties. I would also note that his aunt and his uncle do live in Colorado Springs as well, so he does have significant familial ties. He does currently live with his girlfriend, and his girlfriend is pregnant. Obviously, him being the father of that child, he needs to be able to get out to help her and support her. He does support her and will be supporting this child. It seems to be that he is the sole provider for both of those people. And if he remains in custody, then he will not be able to support them. Obviously, having his girlfriend be pregnant, she's going through additional medical needs than the average person who's not pregnant, and he needs to be there for her. He does have transportation. He can use either rides, or his girlfriend does have a vehicle and can support or get him to and from court. He also has access to a cell phone, so he can stay in contact with his attorney moving forward, as well as get alerts from when his court dates are. He does have some significant medical concerns. He has a blood clot in his right leg, and he generally receives medication for that. He's not receiving the medication while in here. Obviously, that can only further exacerbate the symptoms that he experiences with that. He also has some hearing problems. He's almost deaf, and in his right ear. And so for all those reasons, we would be requesting a PR bond in this case, or a lower than standard cash surety or property bond.
Thank you. What is the DA's position?
And Your Honor, people are asking for a cash surety property in this case. I would note the charge of vehicular eluding and the inherent risk that poses. The defendant was refused to pull over several times for officers. When an officer pulled in front of his vehicle with the cruiser, giving the defendant plenty of time to stop. The defendant then crashed in the patrol car and kept on going. I'd also like to note some previous case history. In 25 CR 943, which is a felony DUI case, The defendant went to preliminary hearing on August 14th, 2025.
He's shaking his head because he was just read that he hit a police car and kept going. And that's dumb.
In 25T4513, which was the next court date for this defendant in El Paso County on October 21st of 2025. In Division H, the defendant failed to appear. The defendant then failed to appear back again in 25CR943, the DUI case, on December 11th for pretrial readiness, and then on December 15th of 2025 for jury trial. So the people have very strong concerns that this defendant is not willing to appear at future court dates.
Thank you. Mr. Gardner, the court has considered your individual circumstances. I have considered your other criminal cases. I've considered the statements of your attorney, and I've considered the position of the district attorney. I have concerns about your ability and willingness to appear for court. You failed to appear for pretrial readiness and jury trial on a felony DUI case back in December. And this is the next time we've seen you or heard from you. I don't have any evidence that there was any attempt to turn yourself in over the course of those 5 or 6 months. And the behavior that is alleged in the probable cause affidavit for this case certainly represents a danger to the community in terms of the manner in which you were alleged to have been driving. The bond will be set at $2,000 cash, surety, or property.
He FTA'd his trial, Judge. And then he just was driving drunk again, hitting a police car, Judge. Don't you mean like $20,000 or $200,000? Did you really just say $2,000?
And your next court date for this case will be June 1st at 8:30 in Division 4. Thank you. Carlos Headland. Hi, what's your name?
Carlos Headland.
Did you watch the video today?
Yes, ma'am.
Any questions about your constitutional rights?
No, ma'am.
I do find that the defendant appears before the court in custody. There is probable cause in case number 26M3319. The charges are harassment, class 1 misdemeanor, and then a second count of harassment as a class 2 misdemeanor. Do you understand the possible penalties for those charges?
Yes, ma'am.
I do find this to be an act of domestic violence. Do we have Melissa Headland on the line?
Yes, Your Honor, I'm here.
Thank you for being here. I will be making decisions today about bond and about the mandatory protection order. You are welcome to address the court, but you're not required to do so. What, if anything, would you like me to know?
Yes, Your Honor. I'm currently staying elsewhere at this time, and I wouldn't want unnecessary harm done to his future or his employment, as we do share a 5-year-old daughter together, and I wish the best for him. During this specific incident, there was no physical domestic violence or harassment directed towards me that made me feel that uncomfortable. My main goal right now is simply just space and stability for everyone to move forward calmly. I would be comfortable with a PR bond.
So you are not currently residing at the marital home, I guess you could say?
I am in the middle of getting an apartment that I should be moving into tomorrow, so I will just have to grab a few things outside.
All right. In terms of timing, when do you anticipate being fully vacated from the marital home?
I'm currently residing in a hotel at the moment, and I plan on, I'm waiting on approval status for my new apartment. If it is approved within the day, I will be vacating tomorrow.
All right, thank you.
Mhm.
Sir, the court will set the terms and conditions of the protection order. You are ordered to have no contact with Melissa Headland. You are ordered to vacate the home that she lives in. You are ordered not to share the same residence with her. I will also, for the safety of the victim, order that you not possess or consume any alcohol or controlled substances. Sir, do you understand and acknowledge the terms and conditions of the protection order?
Yes, ma'am.
Sorry, briefly, Your Honor, just on the topic of the protection order, Mr. Headland did let me know that his 5-year-old daughter's birthday is in 4 days. I don't know if the court would be willing just to grant a 1-day exception where if there is a public place or incidental contact, just so that he is able to see his daughter on her birthday. I don't believe his next court date will be before her birthday, and I'd hate that he would miss his daughter's birthday due to the protection order.
Well, it wouldn't be due to the protection order. It would be due to his underlying conduct that prompted the need for a protection order. But I will make 2 exceptions to the no contact order. So there's one topic, sir, that you can discuss with Mrs. Headland, and that is your shared child. The only way that you can discuss that child with her is over the Talking Parents app that you both put on your cell phones. The second exception will be that if there are going to be exchanges of the child from one parent to another, those exchanges need to take place inside of a police station. Sir, do you understand those limited exceptions?
Yes, ma'am.
All right. So let's see, where was I? I will make a finding of force. Oh, I wanted to clarify one thing. Since at this point in time, Mrs. Headland has not completely vacated the shared apartment, you are not to return to that apartment until the protection order is modified by another judicial officer. So do you need to keep the peace order to get property out of that shared apartment?
Yes, my 2 dogs.
I will authorize, on one occasion, you may go back to that residence, but only when you have arranged for law enforcement to be there with you. The purpose is to retrieve a few basic items of your personal property. If there is a concern about whether those dogs are shared property, police will not allow you to take them. Do you understand that?
Yes, ma'am.
All right. Let's see. I will make a finding of force. That means that within 24 hours of your release from custody, you are required to relinquish all firearms within your possession or control, and you must complete a firearms affidavit. Does the defense wish to argue bond?
Yes, Your Honor. I would be requesting a supervised PR bond for, excuse me, I'm sorry, for Mr. Headland today. He does have significant monthly expenses and only receives a little bit of government income assistance. He receives about $55 a month of EBT. He is currently working. He works at the Broadmoor on their golf course and has been doing that for approximately 4 years now. He's also planning to register to go back to school at UCCS online. He's lived in Colorado Springs for 3 years with his wife and daughter, but he has indicated that he does have somewhere else to stay in the meantime, so he makes sure he does not violate that protection order. He also has his parents here in town. He does have a vehicle, so he can get transportation to and from court, and as well as having an access to a phone to sign up for pretrial text reminders, as well as staying in contact with an attorney. We didn't note any other criminal history, and a CPAT score of 1 was what he was awarded, and it looks like pretrial services is recommending an unsupervised PR bond. So I would be asking for a PR bond in this case. Thank you.
Thank you. What is the DA's position, please?
Your Honor, I'd be asking for a standard custody property in this case, noting the allegations of dozens and dozens of calls to the victim. The note in the probable cause affidavit that was not the extent of what happens. And then I would also just point the court or draw the court's attention to the statement from the defendant that he was going to run to Texas and that no one will be able to find him there. So that gets the people concerns for the defendant's willingness and ability to comply with future court orders and attend future court dates.
Thank you. Sir, the court has considered your individual circumstances. I've considered your lack of prior criminal history. I've considered the statements of your attorney, the input from the victim, and the position of the district attorney. I do have some concerns for the safety of the victim, given the allegations in the probable cause affidavit. It is alleged that you were essentially heard making statements incriminating yourself of having struck the victim. There is also the issue of repeated unnecessary phone calls. And that statement read by the prosecutor does concern me as well, that you had the intent to leave the state and go to where no one else could find you. That balanced with your lack of prior criminal history means that the court is going to not grant a personal recognizance bond, but I will send a $1,000 cash surety or property bond. It will be a condition of your bond that you not possess or consume any alcohol or controlled substances. You'll need to submit to random sobriety monitoring upon your release from custody. And you'll need to attend court on May 26th at 9:30. That's in Division K. That's here in the El Paso County Courthouse. And Mrs. Headland, you are welcome to attend that court date, and you are not required to be there. If there does need to be any modifications to the protection order, those can be addressed at that time. Thank you.
Thank you. And just for clarification for Mr. Headland, for the random sobriety monitoring, is that going to be Colorado Health Services?
He'll need to figure that out.
Okay.
So you can advise him about that.
Okay. No worries. Thank you.
He's texting her right
All
now,
right.
over and over.
Colorado Health Services.
We have Tina La Rosa. Hi, what's your name?
Tina Rose LaRosa.
Thank you. Ma'am, have you been advised of your constitutional rights?
Yeah,
And do you have any questions for me about your constitutional rights?
yeah, I was just wondering if, because I've been in here for almost like 3 months, if you would give me time served.
Well, we're not making any decisions about a possible sentence today. We're here to
Yeah.
discuss just your charges and
I
your
like
next
Spear.
court date and things like that. So you can certainly have some private discussions with your attorney regarding how you want to resolve
No,
this
OJ,
case.
too soon.
Either setting the case for trial or pleading guilty or some other way.
Yeah, I would like to plead guilty.
I understand, but I'm not accepting your guilty plea today. You can
Guilty.
talk about
She's
that with
guilty.
your attorney, and you can consider doing that at your next court date. All right, so.
So am I going to be
you are
out here before my next court date?
Just listen here, okay?
You are here for case number 26M2009. The charges are third-degree assault, Class 1 misdemeanor, resisting arrest, Class 2 misdemeanor, and obstructing a peace officer, a Class 2 misdemeanor. For a Class 1 misdemeanor, you're facing a possible jail sentence from 0 to 364 days and a fine from $0 to $1,000. For a Class 2 misdemeanor, you are facing a possible jail sentence from 0 to 120 days and a fine from $0 to $750. My understanding is that the defendant is on a summons for this case, so I don't think we need to address bond. The next court date we have is scheduled for June 5th at 8:30, and that's in Division D. That's here in the El Paso County Courthouse. Ms. D'Amato, anything further?
No, Judge, nothing.
Okay. Thank you. You're all set.
Okay, thank you.
Angel Lieferman? Sir, would you prefer to sit down?
They're bringing a chair.
Oh, great. Thank you, Deputy.
Absolutely.
All right, sir, tell me your name, please.
Angel Lieferman? Yeah.
Thank you. Did you watch the video that was played in the room?
Yes.
Do you have any questions about your constitutional rights?
No, ma'am.
I do find that the defendant appears before the court in custody. Your case number is 26CR2327. There is probable cause for aggravated robbery, a Class 3 felony. Do you understand the possible penalties for that charge?
Yes, ma'am.
All right. Your bond is set at $25,000 cash.
First off, you're supposed to consume fruits and vegetables. Every doctor tells you that. Fruits and vegetables. Except the carnivore diet. But don't worry about that one. Vodka is made from a potato. So it's completely fine. And it's 4:30 a.m.
Surety or property. Does the defense wish to argue bond today?
Yes, Judge, we'd be asking for a supervised PR bond or in the alternative, a lower than standard cash surety or property bond. I understand the allegations here as well as the nature of the class of felony. However, Mr. Leiferman has no criminal history whatsoever. This appears to be his first offense. Obviously, given the fact that it's allegations at this point, he is innocent until proven guilty. Pretrial services places him in a CPAT score of 2, which is extremely low, as well as the lowest risk category of 1, putting him at a public safety rate of 91% and a court appearance rate of 95%. Mr. Leiferman cannot afford to post any extreme amount of monetary bond. He was on food stamps and has to reapply to be on food stamps. I think this further substantiates that fact. He also, he is working. He is a caregiver for his mother and has been doing this since 2025. He resides with her and she needs constant care. And so obviously him being in custody prevents her from getting the care that she needs. And so he needs to be able to be released to continue that care. He's lived in Colorado Springs for a year, but has lived in Colorado his entire life. So he does have significant community ties. He also has significant familial ties. Not only does his mother live here, but his entire immediate family lives here. Like I said previously, he lives with his mom, so he has living stability as well as employment stability through her. He does have transportation to court. He can use public transportation or get rides from other family members or other friends in the community, and also has access to a cell phone. Obviously, the court is well aware that he's facing some medical things right now in terms of his foot. He's on crutches. And so, and the living conditions here, I think, exacerbate those symptoms that he's feeling currently. So he needs to be able to get out to get properly treated. So for all those reasons, we'd be asking for a PR bond or any alternative, a lower than standard cash surety or property.
Thank you. What is the DA's position, please?
Your Honor, the people will be asking for a cash surety property in this case. I note that the defendant is alleged to have held the victim at gunpoint, grabbed the victim from behind around his neck, then struck the victim over the head with a handgun. The defendant is then the one who went through the victim's pockets, stole the items, and then struck the victim again with a handgun. I would also note that the defendant has a recent case in another county alleging assaultive behavior, and that the injury to the defendant's foot is apparently of his own doing.
Yeah, that's right.
I don't think he knew the guy. I don't know, but I don't think so.
All right. Sir, the court has considered your individual circumstances. I've considered the statements of your attorney, and I've considered the position of the district attorney. To your credit, I did not see any prior criminal convictions. However, the allegations in the probable cause affidavit are very serious. They do involve aggravated robbery, specifically the involvement of a firearm. This was allegedly done in conjunction with 2 other individuals. The court does have concerns for the safety of the community based on those allegations. However, I do note your age and, like I said, your lack of prior criminal convictions. I am going to reduce your bond from $25,000 down to $12,000 cash, surety, or property. Will be a condition of your bond that you not possess any weapons. You will be attending court on June 1st at 8:30 in Division 5. That's here in the El Paso County Courthouse. Thank you. Miranda Pacheco.
And I don't know if you're able to hear it either. There's some really rough feedback coming through on our end. I don't know if it's coming from our microphone or your microphone, but just as a heads up, it was kind of a weird vibrating noise.
Okay, yeah, that's weird. We're not hearing anything here on our end.
Yeah, we only heard it, so I just thought I'd bring it up just in case you heard it as well.
What? Oh, really? Okay, well, if you have, I'll speak as clearly as I can, but if you have difficulty understanding me, or if you need me to repeat myself, I certainly will do so.
Right, thank you.
Ma'am, what is your name?
Miranda Pacheco.
Did you watch the video today?
Yes, ma'am, I did.
Do you have any questions about your constitutional rights?
No, Your Honor, I don't.
I do find that the defendant appears before the court in custody. There is probable cause in case number 26 CR 2271. The charges are vehicular eluding, a class 5 felony, reckless driving, a class 2 traffic misdemeanor, and speeding, a class 2 traffic misdemeanor. Do you understand the possible penalties for those charges?
Yes, Your Honor, I do.
Your bond is currently set at $2,000 cash, surety, or property. Does the defense wish to argue bond today?
Yes, Your Honor. I would be requesting a PR bond for Ms. Pacheco today. She does have a CPAT score of 1, and pretrial services is also recommending a supervised PR bond with just the conditions of complying with court conditions and appearing in court as ordered. We did not see any case history within the last 5 years. The last case that we were able to find was a class 3 misdemeanor back in 2014, so 12 years ago. Ms. Pacheco has almost no ability to post a monetary amount of bond, and she does have significant monthly expenses. She's also on food stamps and receives Medicaid. She's currently self-employed. She does house cleaning, but makes a limited amount of money per month doing that. Prior to that, she was doing rental work for Airbnb. She's been in Colorado Springs her whole life and has her whole family here. She does currently live with her dad and her children, who are 10 years old and 2 years old, and she is the sole caretaker for those children. She does have her own vehicle, so she does have transportation to and from court, and she does have access to a phone to stay in touch with an attorney. So based on all of that, I would be asking for a PR bond in this case today, Your Honor. Thank you.
Thank you. What is the DA's position?
Your Honor, we're asking for a custody property in this case, noting the allegations of vehicular eluding. I'd also like to point out, vehicular eluding is inherently dangerous, but I'd like to point out the location of this, that this started on Pikes Peak. The law enforcement officer attempted to stop the defendant. The defendant then ran a red light at Iowa, and it sounds like the officers broke off the pursuit then because of the danger of the community. And it was only later when the defendant was changing a tire that I think was flat on I-25 that she was later contacted. So officers knew that this was too dangerous for them to continue that pursuit, which just shows the danger that the defendant was putting the community in through her eluding.
Thank you. Ma'am, the court has considered your individual circumstances. I've considered your other criminal cases.
That would be me. That would be me. Please start chasing me. I lose them in a dangerous area, and then I get a flat tire, and then I get picked up. That would be me.
I've considered the statements of your attorney and the position of the district attorney. Looks like your most significant case was, previous case was from 2013. It looks like you were found guilty of a class 3 drug felony. Probation was revoked and you were sentenced to community corrections. The allegations here are concerning to the court. The allegations of eluding here do put any number of people on the roadway at risk: pedestrians, other motorists, your own passengers, law enforcement. And the court is not going to grant a PR bond, but I am going to set your bond at a reduced amount, $1,000 cash, surety, or property. Ma'am, your next court date will be May 26th at 8:30, and that will be in Division 13. That's here in the El Paso County Courthouse.
Thank you, Your Honor.
Jane?
Case. Is there any objection by either party to adopting the recommendations in that report that Mr. Hayes is competent to proceed?
Not from the people, Your Honor.
Thank you. All right. Given that stance by both parties, the court will adopt that recommendation and find that Mr. Hayes is competent to proceed.
Being good is hard.
Therefore, this matter can proceed at this
So
time,
hard.
and the toll will be lifted. Mr. Hayes, I haven't handed a plea agreement, okay? I'm going to review that with you at this time. But first, I need to ask you a couple questions. First, are you thinking clearly today?
Yes, sir.
All right. And are you under the influence of any alcohol, drugs, or anything that would impair your judgment?
Negative, sir.
Okay. Have you had enough time to talk to your attorney about this?
Yes, sir.
And are you satisfied with his representation of you?
Yes, sir.
All right. So this would have you plead guilty to count 1, aggravated motor vehicle theft in the first degree in violation of 184409. This is a class 4 felony and a conviction would enter. Second is to count 2 in 23 CR 5007, vehicular eluding with injury. A conviction would enter as to this offense, and that is a class 4 felony. Count 3, driving under the influence in violation of 42-4-1301, a class 1 misdemeanor, would also see a conviction enter. Is that your understanding of what you would be pleading guilty to, sir?
Yes, sir.
Okay. Now, there is a sentencing agreement in this case that you would serve 15 years in the Department of Corrections through consecutive sentencing. Is that your understanding?
Yes, sir.
Okay. And as to count 1, the parties do agree that there are extraordinary aggravating circumstances and that you would serve 7 years in the Department of Corrections on that count. As to count 2, the parties are agreeing that there are extraordinary aggravating circumstances that would merit 8 years in the Department of Corrections consecutively to count 1. As to count 3, you would serve 356 days jail. Did you mean 365 days jail?
Yeah.
Okay. I'm going to correct that. Any objection?
No objection.
Okay. So as to count 3, you'll serve 365 days jail with 365 days credit for time served. Count 3 will run concurrently with counts 1 and 2. Is that your understanding, sir?
Yes, sir.
Okay. Then you need to pay any costs or fees, as well as any restitution. You would need to pay $44.50 in prosecution fees, as well as $63,745.90 in restitution. Do you understand that, sir?
Yes, sir.
And are you agreeing to that amount?
Yes.
Okay. And upon sentencing in this case, La Plata County cases 24 CR 298, 24 CR 365, and 23 CR 208 will be dismissed. Also, 26 CR 105 will be dismissed. Is that your understanding?
Yes, sir.
Okay. Now, sir, when you enter into a plea agreement, you do waive a number of your rights, okay? So you do have the right to a speedy public jury trial where you'd be represented by your attorney. At that jury trial, the district attorney would be required to prove each and every charge against you beyond a reasonable doubt, okay? At that trial, you could cross-examine any witness called against you. You could also call your own witnesses, and you could take the stand and testify if you chose to do so. If you chose to remain silent, your silence would not be used against you, as you do have a constitutional right to remain silent. And if you were to lose that jury trial, you'd have the right to appeal any result to a higher court. So do you understand all those rights?
Yes, sir.
Are you comfortable waiving them for purposes of this plea agreement?
Yes, sir.
Okay. Now, sir, do you understand what it means to commit the crime of aggravated motor vehicle theft in the first degree?
Yes.
And have you discussed that with your attorney?
On a completely separate note, I'm selling snakes in the United States for $5,000 each.
Okay, and have you discussed what it means to commit the crime of vehicular eluding with injury with your attorney? And do you understand what that means as well?
Yes.
And do you understand what it means to commit the crime of driving under the influence?
Yes.
And have you discussed that with your attorney? Okay. Counsel, have you advised your client as to the elements, and are you comfortable waiving further advisement as to the elements?
Yes, sir.
Great. And sir, with respect to those 3 charges, have you discussed the possible penalties with your attorney?
Yes, sir.
Do you understand all of those possible penalties? Okay. And counsel, have you advised your client as to the possible penalties for these three offenses? And are you comfortable waiving further advisement at this time?
Yes, sir.
All right. The court will.
Oh, you were just gonna send pics of snakes. My bad. I went full snake.
Accept the waivers. All right, so it's important to understand that if you plea in a criminal case and you're not a U.S. citizen, there is the possibility of immigration proceedings being initiated against you. These could be as severe as removal proceedings from the United States. It's also important to understand that this agreement is between you and the district attorney. It's not between you and the court. As a result, I could refuse to accept this agreement. And if I did that, you'd be allowed to withdraw your guilty plea and have this case set for trial. Do you understand that?
Yes, sir.
Okay. Additionally, the district attorney is reserving the right to withdraw from this plea agreement should the court decide not to impose any terms of the agreement, as all terms are material. And the district attorney is reserving the right to withdraw from this plea agreement if you were to commit a new crime between now and sentencing, or should new criminal history be revealed to their office between now and sentencing. Do you understand that, sir?
Yes, sir.
Okay. Sir, is this how you would like to resolve this case?
Yes.
And is- All right. Is anyone enforcing you or coercing you to do this today?
Sir.
All right. And has anyone made you any promises outside what we've discussed?
No, sir.
Okay. I see a factual basis listed on pages 7 and 8. Do we have a stipulation of that factual basis, counsel?
So with regard to stipulation, so the state spent a lot of time on that factual basis. With regard to the factual basis, my client has consistently kind of maintained he doesn't have a lot of memory with regard to the actual facts written there, but he is willing to stipulate that he thinks that a jury would be able to find those facts, find the guilty of those facts at a trial.
All right. And are people comfortable proceeding in this manner?
I am, Your Honor. I would like to submit, I think, as an exhibit, at least for sentencing, there's dash cam footage of the entire incident. The entire thing is captured on camera, and I plan to submit that to the court. But I think my factual basis accurately reflects what the camera footage shows. So I'm asking defense just to stipulate that those are the facts.
All right. So, counsel, ordinarily on this level of a charge, I don't ordinarily accept an Alford plea. I would expect him to either stipulate to the factual basis.
It's not quite an Alford plea, Your Honor, if I can quickly clarify. So my client has been able to review the facts, the evidence. He agrees with all of the evidence as it's been presented. With regard to independent recollection of driving, probably with that he doesn't have, but with reviewing everything, we will agree that from what he's seen, those are the facts.
Yeah.
Okay. So you agree that those are the facts and that
Yes, sir.
and that they do establish the elements of these crimes?
Yes.
Okay. Mr. Wills?
I'm comfortable with that. I mean, he is pleading guilty to being intoxicated. It's clear from the video he was intoxicated. As far as the knowing mens rea from counts 1 and 2, we would, I believe, get a jury instruction that the jury would look at that from a perspective of someone that was sober. So I understand what you're saying. He doesn't quite remember everything because he was intoxicated, but he's stipulating to those facts based on his review of the evidence. That is what happened.
All right. All right. So I will go ahead and accept the factual basis that's been presented to the court in pages 7 and 8. And Mr. Hayes, I see a signature on the last page of the plea agreement. Is this your signature?
Yes, sir.
And does this mean that you read, understood, and agreed to this document?
Yes, sir.
All right. Sir, do you have any final questions for the court or your attorney before we proceed?
Yes, sir. I just want to do because it's taken a long time for this specific case. I just want to do immediate sentence and just get it over with because the jail that I'm at right now, they don't really find me constitutional at all. They keep me in ADSEG for no reason, really. They hold these past crimes like this one against me, and they just keep me in ADSEG for, whatever they think. And it's not really good for my mental health and for my health, period, like physical health. And I just want to get it over with.
Judge, jail is not good for my mental health, Judge.
Take this plea that I did do this crime. I know that I did this crime.
Okay.
Sure.
Mr. Wills?
I'm going back and forth on this, and we're sending a man to prison for 15 years. I am aware of his criminal history. I would like to submit the video as an exhibit.
Yeah, and before we get to that, though, do we even have VRA for immediate sentencing?
I've spoken to the victims of all the other cases.
Okay.
They're all
You
aware
have them there?
that they would be dismissed as part of this global plea. They were all fine with it. So I am VRA compliant to go forward with sentencing
Okay.
at any time.
Peanut butter. Crunchy peanut butter.
And if your honor's comfortable with that, I suppose I'd be comfortable with it as well, but I would like to submit the video into the record. I think it's important. It's a pretty intense driving experience that I think should be part of the record, but I would defer
I wanna
to
see
your
that
honor.
video.
If we want to go to immediate sentencing, that's fine. If you want a recitation of his criminal history, I could try to get that for you right now. But typically we would ask for a PSI in a case like this.
They're crackers.
If I may, Your Honor.
Yes, please.
Like
So we
whole
would
grain
stipulate the
crackers.
state's admission of the video. There's no issue with that. I was going to say a lot about this. I have pointed out as the court. Pointing it out, just kind of getting the elephant out of the room. This is not normal. Typically, before Mr. Hayes, typically the court is always going to get PSI on this kind of level, especially in the 15 years. This will make courts feel comfortable, but in his situation, it is more unique. He's been before the court.
Did you ever have frosted mini wheats? Do you have them there, Frosted Mini Wheats? I think you should. So they're like that, only salted. They're like a cracker made like that.
3 years. The court's gotten numerous competency evaluation reports back, been able to review several data. I mean, at this juncture, I think probably all the parties in here, including the court, could probably provide additional data to the PSI once we're done. Everyone here is extremely aware of Mr. Hayes. We know what's going on. We have a lot of his history is being dealt with today, actually, and there's substantial additional history beyond that. But I think the state can give a very quick analysis. I think that both parties are presenting strongly that this is a fair sentencing agreement. It is a lengthy amount of time. At this juncture, I think that instead of just trying to check the box, to just check the box, Mr. Hayes is desperate to address this matter today. The 23 hours is really driving him kind of crazy. He feels that it's just really painful for him every day sitting in there. He gets to sit in there for another 6 weeks just to wait for a PSI report that we don't think is going to provide a lot of information that we're not already aware of. It's kind of just hard for Mr. Hayes. So he's just asking you to reveal a understanding, kind of, it's almost a little sense of mercy, just sit him a day, allow him to start going to DOC and be processed. So he's begging the court at this juncture to just move to immediate sentencing, take the state's video and the recitation of his criminal history and sentence him a day.
Okay. And Mr. Wills, will you be able to, are you in a position to make a record as to why the court should accept this agreement, particularly given the two portions regarding extraordinary aggravating circumstances? I want to make sure that's abundantly clear in the event that this does come back on a Rule 35 motion.
Yes, my understanding is we did provide a document showing that he was on parole at the time. It's a document from parole. I think that would be a per se finding of aggravated or extraordinary circumstances under, I think it was subsection 8 of, I'm forgetting the statute that governs that. I think it was subsection 8. Additionally, I provided a substantial factual basis for the court to make a legal determination that it was extraordinary circumstances. I think subsection 7 says that the court would have to make a clear record on the facts and circumstances of the case and determine that indeed it was extraordinary circumstances. So I would ask that the court do that so that we're absolutely certain we've met the criteria for extraordinary circumstances. And one of the reasons I wanted to submit the video is so that the court would have that and have reviewed that in making that determination. So I do think a record is required from the court for the factual basis way of getting to extraordinary circumstances, but we have a document from parole saying that he was on parole at the time.
Okay. Then if we can produce that document today, and I will allow the video that's been stipulated to be played. I will allow immediate sentencing at this time.
I can play the video, but it's 28 minutes long, Your Honor, and it's basically the full 20 minutes is action packed. And
So if we can see this video, then we'll watch it. If we can't see it, we're not going to sit around for 28 minutes.
it would take a while for you to watch it, but.
Can you cut to the important moments of it?
I may move out the lawyer, and I have a copy of the document that's provided by the state with regard to parole.
Okay. And I believe I've just been handed that document.
Oh, I think I submitted it. Sorry.
All right. And the court notes that it's been handed a document regarding parole that the parties have stipulated to. Is there any objection to me marking this as Exhibit A?
No.
Mr. Wills?
No objection. Okay.
All right. So before we get to the video, Mr. Price, do you have anything further with respect to sentencing?
Just very quickly, Your Honor, I think that the sentence being presented to the court is very fair. It is a lengthy sentence. The issue, and I think this has kind of come out a lot, is trying to discuss who Mr. Hayes actually is. I know the state has kind of represented that, Mr. Hayes is a bad guy. He's a criminal. I've discussed that with Mr. Hayes, and the issue is Mr. Hayes hasn't, at a point like this where you start getting to this level of criminality and where you have this level of sentence, I can see how people start to just give up and how the court starts to give up. The one thing that I do commend Mr. Hayes for is he's not giving up on himself. We frequently have discussions about him having a severe addiction issue. And I think that's very apparent through all of his cases. The most recent case being dismissed at 26 CR. He was found completely incoherent on the street. He just got out of treatment. Everything was going well, but I think as the court has seen numerous times, somebody gets out of treatment and just that happens. It's that slip up, and Mr. Hayes was so horribly intoxicated. He didn't really know what was going on. He thought, I guess at one point he answered he was in Colorado Springs. And that's what Mr. Hayes has been reiterating through a lot of this. He's had a lot of PTSD in his past. I think the court's very familiar with regard to competency evaluations that life is not that easy for Mr. Hayes. And it's very clear that he self-medicates. And when he self-medicates, he does stupid things. I think that's how he described this right here. He was self-medicated horribly. While he's going through the situation, I think the court will see he's clearly not altogether. He's just screaming slurs. Sometimes he didn't make sense. He's just basically like he's in the throes of emotions and a high. It's very clear that a high is just kind of taken over him and he's committing these acts. He understands it's not at all acceptable. He's actually very, very sad and ashamed of it. He's just really wishing that he understands that if he can get a grasp on his addiction, he can be a good person. And that's where I'm really proud of Mr. Hayes is he hasn't given up on himself on that. He really, really has the desire to just be a good person, be somebody who can benefit society and do the right thing. He just knows that he's had a lot of bumps on the road there. And so he's asking the court to kind of take that into consideration, but he's not giving up on himself. He hopes society doesn't give up on him either. He understands this is basically been going away for a long period of time, but he's very optimistic that when this is over and he's got this behind him, that he's going to get a grapple on this substance abuse issue and come back and actually be a productive member of society. That's his sincere hope, and it's just asking everybody else to kind of hang with him and give him a little more time, even though it's kind of gone on this way. So that's all I really have to add. Sentencing.
All right, thank you.
I bet you Louis would love
Mr. Wills, are you ready with the video?
I am, Your Honor. I'm getting some timestamps together.
Let me know when you'd like me to switch it to your video.
We can do it now, Your Honor. I think I could shuffle along through it for you. And then I will submit the video later on a flash drive to the court. Is that
because
that's
the
fine? Thank
prosecutor
you.
said that this video was 28 minutes action packed.
right? The people will publish from. We'll make that People's Exhibit 2. Is that what you'd like it to be? Since the document was out.
I think it started with letter. Has this previously been labeled?
It has not.
Okay, can we just do Exhibit B then?
Exhibit B.
Yes, thank you.
I do not like off-brand peanut butter either. It has to be Jiffy. I guess there's a lot of sugar
No
in it.
objection to admission.
Thank you. So the court will admit what's been marked as Exhibit B.
Publishing from 27 seconds into Exhibit B.
I think I'm about to be disappointed. I can't tell if it's a man or a woman. I don't know. I'm gonna fast forward it just for a second to see if...
Oh, Dick.
Hold on.
Oh, Dick. Okay. Dick, good. You guys ugly there. Oh, Dick.
We'll fast forward to another minute. He just sits here for about a minute.
Okay.
Publishing again at 2 minutes, 26 seconds.
What's up? He got me a butt. He got me a butt. I'm going, Josh. I'm going, Josh. Let's go, Josh. I'm going, Josh. Bye, dude. I'm going, Josh. Josh. I'm going, Josh. Oh, Josh. Come on, Josh. Oh, Josh.
Fast forward again to 8 minutes in. 8 minutes and 2 seconds.
Oh, dear. Oh, dear. Give me nigga.
Alright, we get it. I'm gonna bump it forward, or we'll go through 28 minutes of this, and we can't really see anything. I'll skip more towards the end. That's still pretty. There we go.
That would have been instant death for that person as well as you. So the community is extraordinarily lucky that there weren't deaths on this date. But the court does recognize that under this set of facts, this is an extreme case that does merit the court finding that there are extraordinary aggravating circumstances. So for both the facts in this case as well as the fact that you're on parole, the court does agree that there are extraordinary aggravating circumstances and does find so at this time. Therefore, Mr. Hayes' conviction will enter as to count 1. The court does find that there are extraordinary aggravating circumstances as stipulated to. And I will sentence you
If I had a guess, I would say that's a woman.
to 7 years in the Department of Corrections. There will be a mandatory period of parole of 3 years on that offense. As to count 2, conviction will enter. I will find that there are extraordinary aggravating circumstances as to this count as well. I am sentencing you to 8 years in the Department of Corrections. This will run consecutively to count 1. And then as to count 3, and there will be 3 years mandatory parole on count 2. As to count 3, conviction will enter. As to the DUI charge, I will sentence you to 365 days. Concurrent to counts 1 and 2. Mr. Price, do you have a pre-sentence confinement credit calculation?
Judge, I did. It was about 1,070, but there was the Valor period where he did have a PR bond. I did negate that. It's on my computer in my office. I believe it's about 970 days. I could go to my office and send that to the court in about 10 days, or in about 10 minutes.
Okay.
If I could just get the court the email on my laptop, CC the state, and make sure that I send that ASAP, and I can get it to the court very quickly. It's over 900 days, roughly 970. So I apologize, I don't have that on me right now.
All right, Mr. Wills, any objection?
To him submitting a document, no objection to that. I don't have a number either, so I'll look out for that. And
I can run through it a little quickly, Judge. I think there was 400 days custody. That was due to a parole hold that was helping hold him. That was immediately upon arrest. Then he was released. That was right when I entered my appearance. He did another 30 days in custody, and he posted bond again. He was picked up again and held. Now, he was actually arrested September 5th on another matter, but he was technically on a bond on this matter until bond was revoked on September 9th. So I started counting again on September 9th from that period. Went to the Valor Date program when he was actually released to Valor, in which the court was gracious enough to give him a PR bond so that he could attend that treatment. And then I started again from the time a warrant was issued after he was out of the Valor program. He was arrested on the new case, the 26th case, and the warrant for this matter also hit on that day. So I started counting from that day to the present day. So I can send those 4 periods. I have them all worked out already on the computer. I can send all those to the court along with the final calculation, and I believe it's right around 970 days.
All right, so I will grant the request to submit the pre-sentence confinement credit by the end of the day, okay?
Thank you.
All right, and then I will grant the restitution request. And that is in the amount of $63,745.90, as well as costs of prosecution, which are $44.50, and any costs, fines, or fees. On the DUI, I will set the mandatory fee at $600. Okay. Given that the court has accepted the plea agreement and sentenced you in accord to the plea agreement, at this time the court will dismiss 26 CR 105, 24 CR 298, 24 CR 365, and 23 CR 208 in their entirety. And the remaining charges in 23 CR 5007 will be dismissed as well.
It's probably Baca. You're right. It's because out of the 3 that I saw, it's probably Baca. Except we don't know if it's pro tem. We don't know if there's a temporary judge on the bench today. We can't see.
Is there any objection to me applying the pre-sentence confinement credit as to count 3 and count 1, since count 2 will run consecutively?
The count 3 running concurrent to both count 1 and 2. Is that what you mean?
I've ordered that they run concurrent, but I want to make sure the pre-sentence confinement credit is done correctly. So I was planning on applying it to count 1 so that it wouldn't be applied to both cases, essentially giving him concurrent credit on both counts 1 and count 2. Does that make sense?
I suppose it makes sense. I don't think we discussed that. That's fine.
Any objection? Okay, so I will apply the pre-sentence confinement credit to counts 1.
Okay, we get it. He got 8 years. Right? 8? Right? I'm fine. I worked 16 hours yesterday, and now, you know, I'm gonna do it again today. That is, I'm just, in a couple days I'll have off. Friday's an easy day. So today's Thursday. It's my last hard day. Let's go with this one.
Then I'll call Mr. Dick to get Ms. Crane and this gentleman on there with their way. Okay, let's start with Ms. Tomaski. Cheyenne Tomaski, 25M2862, 26CR341, 26M266, 26CR491. Folks, what case are you here for? Yes.
Anthony Wilson.
Okay, great, you're saying, okay?
Hello, Ms. Tomaski.
Hi.
Did you watch the video in the other room, ma'am?
Yes.
With the one with the judge?
Yes.
Any questions about it?
No.
So you understand your rights?
Yes, Your Honor.
Okay. Ms. Heiserroth, well, let me start with this. There's a warrant for your arrest, Ms. Tomaski, out of Montrose County, case 25JD13. The bond is set in the amount of $5,000 cash only. If you're able to post that bond, it's returnable in Montrose on June 10th at 2:30 in Division 3. If you're unable to post that bond, the sheriff of Montrose County will be responsible for transportation. Ms. Heiserroth, do you need further reading or advisement in either the Montrose or Mesa County cases?
No, Your Honor, we would waive.
Mr. Savage.
Thank you, Your Honor. For Ms. Tomaski, I'm asking that the court issue the standard protection order in this case. With Ms. Tomaski, Your Honor.
They don't need a protection order. This is tampering with a dead body, I think. Because she was driving along. Well,
Honor, as the court can see, she's a CPAC category 4. I remember Ms. Tomaski from juvenile court. As the court can see, she has several juvenile adjudications. She's, scored out not just as a CPAC 4, but pretty high on the CPAC court, especially for somebody her age. She has 4 pending cases. She's got 9 prior failures to appear. As the court can see, she was on probation. She also was, I think, out on a PR bond as well. I know that the court set bond at this initially, Judge Henderson, at $25,000 cash. I'm asking the court to leave that bond. I think the bond is set appropriately given all of the things going on. Obviously, there's some serious allegations here as well with, the allegations specifically involving, attempting to influence a public service and abuse of a corpse involving an overdose, allegedly, and an individual who was allegedly, basically pushed out of a vehicle after he overdosed. So based on the totality of things, Your Honor, I think there are significant community safety concerns.
Yep.
I think there's also...
He overdosed in her car while she was driving. She opened the door and pushed him out, then went on her merry way.
Concerns, obviously, with Ms. Tomaski making it to court, that sort of thing. So I would ask that the court leave bond where it is.
Ms. Heiserroth?
Thank you, Your Honor. We are asking the court to consider PR bonds. I believe you're addressing 3 cases today, so we're asking...
That's correct. 2 misdemeanors and a felony.
Thank you. So we're asking for PR bonds in all 3 cases. Just to give you a little bit of background of where Ms. Tomaski's been, Ms. Tomaski was arrested in Texas about 2 weeks ago on these warrants. She was not arrested for anything, she was not alleged to have committed any crimes in Texas, but she was held in jail in Texas until she was extradited here on these warrants. And so that is part of the delay in her appearance in this case. Ms. Tomaski, if the court were to grant her PR bonds in these cases, intends to stay with her brother-in-law. He lives in Mesa County, and so that would be stable housing for her. She does have a cell phone. She has a public defender in her misdemeanor cases and would need to update her application, but would likely qualify for a public defender in her other cases as well. As far as coming to court, Ms. Tomaski intends to get a bus pass, and so she'd be able to take the bus to court. I instructed her that she can go to the Center for Independence, and I believe they have some
Ma'am, sometimes people fall asleep on the bus. Do not start pushing people out of the bus that are falling asleep, okay?
short term. I don't know if they have month-long bus passes, but I think they at least have week-long bus passes that she can pick up from them. Recognizing the allegations in this case, I spoke to Ms. Tomaski about pretrial services. She is willing to comply with pretrial services and any other non-monetary conditions of bond that the court thinks would be appropriate in this case. Ms. Tomaski did share with me that she has been clean for over 3 weeks, so that was before even her arrest. She's very proud of herself for that, and she thinks that she now has a really good base under her to remain clean. She recognizes that drugs are are really the reason that she's in this situation at all, and so staying clean is really of utmost importance. And so I think pretrial services will also be an additional help with that. To help her not only get to court, but also just stay clean, which I think then alleviates her potential risk to the community. And so we are asking for PR bonds.
Yeah, I appreciate that, but given the nature of these charges, I'm keeping bond as is in the felony case in 26 CR 341, not only the charges, but the alleged acts. A bond remains set in the amount of $25,000 cash only. As a protection order and a bond condition, Ms. Tomaski shall not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim of the acts charged. That's the only protection order. As a separate bond condition, shall comply with pretrial supervision through CJSD. In that case, Ms. Tomaski is going to actually don't have it. Do you all have the
Judge Barrett, I believe.
Yeah, Judge Barrett.
I apologize. I'll set this on May 28th at 8:15 in the morning. Moving to the two misdemeanors, I will, it'll be identical bond conditions in each. Bond in each case is set in the amount of $1,000 personal recognizance. In each case, the only condition is both a protection order and a bond condition that she shall not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim of the act charged. I'm going to set that I'm going to set that out a little bit on Judge Rahm's in custody docket. I will set that 3 weeks from today, as soon as I can figure out what day that is. That's June 12th at 1 o'clock in the afternoon. As to the misdemeanors, as to the Montrose County case, I choose not to modify bond. Ms. Tomaski, do you understand everything I just ordered?
Yes, Your Honor.
Would you like me to appoint, I know you have a lawyer in the misdemeanors. You want one in the felony too?
Yes, please.
I hereby appoint the public defender. Thank you very much.
People will be with you in court.
Let's.
All right, this guy did something bad. I don't get it, but he did it. Here we go.
Find that case file.
All right, Ms. Linville, did you have any questions about the rights that the court went over earlier?
No, sir.
In your case, you're on probation for a Class 5 felony.
Yes.
Class 5 felony carries with it a possible sentence to
After she's done, the next guy does something bad. You'll see.
the Department of Corrections between 1 to 3 years. With exceptional circumstances, that could be reduced to as little as 6 months, increased to as many as 6 years. There'd be 2 years of mandatory parole and a possible fine of between $1,000 and $100,000. You have the right to be represented by an attorney in your case. You've been represented by Ms. Bacon. Do you have any, are you satisfied with your attorney services?
Yes, I am.
Do you need any further time to talk with your attorney about your case?
No, sir.
In this case, I have an agreement noted that states you intend to admit to violating condition number 7 Condition number 7 states you will submit to drug and alcohol testing as directed by probation. It's alleged you missed random drug tests on April 23rd and April 9th of 2026. There's an agreement for a 90 days in jail with 90 days credit for time served. Is that the agreement?
Yes, Judge.
And close the case, basically unsuccessful probation?
Yes.
It doesn't matter where I put a dead body in my car. If I'm driving with a dead body in my car, I'm 100% getting pulled over.
Ms. Linville, did you have any questions about your rights?
No doubt.
No, sir.
Understanding your rights in this case, do you wish to admit or deny the allegation you violated condition number 7, submitting to drug and alcohol testing as directed by probation? Do you wish to admit or deny that you violated that condition?
I admit.
Are you under the influence of any alcohol or drugs that would influence your ability to understand today's proceedings?
No, sir.
You suffer from any mental condition or disability that affects your ability to understand these proceedings?
No, sir.
Court finds the defendant has knowingly and voluntarily and intelligently waived her rights in this case. Plea is entered into knowingly and voluntarily without any undue influence or coercion. She understands the possible penalties and the consequences of the plea. Court will accept the admission at this point in time. Are we going to immediate sentencing?
Yes, Judge.
Yes, right. I guess my first question is, we have a class 5 felony with basically no success on probation. It's already been extended once. Why are we terminating?
A fair question. Court's indulgence, I'm sorry, this computer's freezing up.
I can't do that.
Ms. Bear?
She did excellent on probation in the beginning. She went to IRT, she did a year at the sober house, she was working full-time at Arby's, and then she got back into meth, and just everything fell down from there. We couldn't get her back on track.
So I guess I'm not getting involved with whatever we're doing here. I'm just looking at it going, why is ComClone not an option?
Well, she's also on a deferred, so she would be deferred and having a conviction in the record now.
True, but a conviction with 90 days jail and closed, and done on a felony.
Right, well, I think to answer the court's question, Ms. Bear and Mr. Karshner and myself had discussions via email, and Ms. Bear obviously worked with Ms. Linville on these cases the closest. And the best outcome for Ms. Linville is to close this.
Michael, store brand. I'm eating store brand right now because it's cheaper. So I would still eat it.
Out with the cut of her time served, taking into consideration what Ms. Bear made a record to, which was that at one point in time, there was belief that this case would close out successfully. We're just not there right now.
Mr. Karchner?
So, Your Honor, at the time this case came in, Ms. Linville was on a pretty clear downward trajectory. She had the vehicular looting in this case. At that time, we noted that she had 6 failures to appear pending when she was arrested in these cases alone. The offer, and from what I had been told, everything that had been happening to Ms. Linville was related to substance abuse. Probation was an effort to try to curtail some of that. That, of course, didn't work. We're now in a position a year later where there was some success, and I frankly wasn't sure how much the court would credit that success in light of any request we might make. I deferred to probation in this one based on their feelings about whether there was sufficient consequence or not. I was on the fence with this. With that in mind, that's the people's record in terms of how we ended up here.
When reading the complaint, and I don't fault the parties for looking at things, saying she did really well at first, what kind of credit do we want to give her for that? This reads like someone who has given up and has completely fallen off recently. And then when I read a statement that the defendant requests to go to jail rather than to continue probation. Well, this is a felony case. And 90 days jail, which is barely what she has. I mean, I have 79 days plus 16. So, barely have 90 days for a class 5 felony. And I went back and looked at the warrantless. This was not a not serious offense. I mean, just going 90 miles an hour through 4-way stop signs all over town while being chased by cops with outstanding warrants. I think community corrections is a better option than giving up on her and closing the case out. So are the people ready to proceed to a hearing? Because I'm not going to accept this.
Yes, Your Honor.
Judge, I would ask to withdraw the plea and allow me to convene with Ms. Linville about our options going forward and a potential opportunity to rediscuss negotiations with Ms. Baer and Mr. Karshner, Judge.
That's fine. I'll give you that opportunity. I want to make it very clear. I feel like this is just giving up on somebody that who's really given up on herself. And I know how much time has been put into this case. It's an older case, but I'd like to see something aside. Plus, it is a felony case, not a run of the mill, not a misdemeanor, not something less serious. So I'll give you that opportunity. We'll come back in 2 weeks. June 4th at 1:30 for revocation. All right, is this Mr. Willard?
Yes.
Thank you. We'll call 26 CR 5008, People versus Christopher Willard. Mr. Willard appears in custody from the Morgan County Jail. He is represented by Ms. Bacon, who is present here in court today, the people by Ms. Wired. We are set for revocation proceedings, but however, the court has, in response to a sealed motion, ordered a determination with regards to competency. Ms. Bacon, do you wish the court to advise your client with regards to his rights on a competency evaluation process?
Yes, Judge.
Locate that. All right, Mr. Willard, there's been a motion filed in your case, and the court has granted that motion to determine whether or not you are competent to proceed in this matter. Competency is a process to determine whether or not you have the present ability to assist with your defense. You have the right not to say anything to the psychiatrist during the competency examination. Statements to the examiner can be used against you at the guilt phase of trial or at rebuttal or as rebuttal or impeachment evidence. And this is a probation revocation, so it can be used during those periods of time during that particular type of a hearing. You have the right to confer with counsel before submitting to the competency exam. The court will appoint an attorney for you at state expense if you are unable to retain counsel prior to the competency evaluation. You are in custody. You do qualify for the public defender. I do understand there might be something going with that. I will watch for any appropriate motions with regards to that. If you do not cooperate with the competency evaluator and other personnel providing these services, and the lack of cooperation is not the result of a developmental disability or mental disability, the fact of your non-cooperation with the competency evaluator and other personnel providing ancillary services may be admissible in the competency or restoration hearing to rebut any evidence introduced by you with respect to your competency. When a decision is made as to your competency, if you wish to contest that decision, you have the right to request a competency hearing At the hearing, you and the prosecuting attorney have the right to be present in person to examine any reports of the evaluation or any other matter to be considered by the court as bearing upon the determination of your competency, to introduce evidence, summon witnesses, cross-examine opposing witnesses or witnesses called by the court, and to make opening and closing statements and argument. The court may examine or cross-examine any witness called by you or the prosecuting attorney at a competency hearing and may summon and examine witnesses on its own motion. If you are found to be competent to proceed, then the case will proceed as scheduled for probation revocation after such determination and a final
I
determination.
mean, instead of talking about competency, they should just be talking about anger management courses. We're about to hear what he did.
Is made by the court. If you are found not competent to proceed, the court may order you into restoration services and you would be ordered to cooperate with those.
Speaking of wear your underwear on the outside of your pants, Bobby's here. Hi, Bobby.
Restoration services. Do you have any questions about the competency process at this stage?
No.
Okay, and we do have a specialized competency court with a different judge, and that's where your case is going to be transferred at this point in time. So that is a much more specialized that has different resources available and is able to handle competency questions more efficiently than this courtroom can. So that's what's going to happen in your case at this point in time. Do you have any general questions for me at this time?
Yeah, I want to know how I can be released on a PR bond.
Yeah, Judge, we also want to address bond today.
I understand. Let me get to bond here in a moment, but any questions about the competency process?
Not at this time.
Okay, if you have any at some point when you have your attorney talk to your attorney, and you can also, you may be given some opportunity in the competency court itself as well.
It's absolutely horrible.
Okay, well, anyway, let's talk about bond at this point in time. Currently, bond in this case is $700 cash or surety. Ms. Bacon.
Thank you, Judge. I am requesting that Mr. Willard's bond be converted to a personal recognizance bond. I think that based off of this case, we're here for a probation revocation. However, given the timing, Mr. Willard will be supervised on probation out of custody. And Mr. Willard's source of income is Social Security. So without access to that, he is unable to support himself or post bond. For those reasons, Judge, I am asking to convert the bond in this matter from $700 to a personal recognizance bond.
From the people?
I get that you just got a PR bond, but here's the problem. Mr. Willard just pled guilty, whatever, last week? And then 2 days later was arrested. So I'm not certain how compliant he really is on probation. In other words, I understand Ms. Bacon's argument is that he's going to be supervised, but is he? Because I don't see that he's even availed himself of that yet. I suppose the court can err on the side of believing that he will, but I'm not confident in that. Again, he was just granted a $1,900 or $1,500 PR bond on the 19th. That was Judge Leishuk who granted that. And this is $700 cash only, I believe.
I think it's cash or surety now.
Cash or surety, okay. I mean, the court could convert this to a $100 cash only. But if the court's going to grant a PR, then I think it has to match the PR that was granted in the misdemeanor, as this is a felony matter. Oh, and I've been told by his would-be probation officer that he refused to sign the conditions of probation.
Yeah, at this point in time, reading the allegations that he admitted to in this case, I mean, this involves throwing a cinder block through the window of the sheriff's department in the middle of the night.
Dumbass. Why would you do that? What is wrong with you? You can't throw a cinder block through the window of the sheriff's office. Don't do that, anybody.
The fact that he picked up a new case within 4 days of being placed on probation and he refused to sign the probation terms and conditions doesn't give the court any confidence that he'd be successful being supervised at this point in time. I'm denying the motion to reduce bond. We'll set the matter into competency court on June 9th at 10 a.m. Anything further today on this case, Ms. Bacon,
No, thank you, Judge.
Ms. Wyatt?
No, thanks.
All right, we'll see everybody June 9th, 10 a.m., competency court.
All right, guys, we made it. Thank you so much for coming out today. I really, really appreciate it. I hope you guys have a great Thursday, and I will see you tomorrow morning or evening, depending on where you live. Bye, guys.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome